This is the short sale listing addendum, different than the video I just did on short sale addendum. This is a tremendous form that I would use in my practice to counsel people who don't even want to do a short sale, or people who are like that it's a tool, but first let me stay in my house as long as possible, save the money, be prepared to reinstate if I have to, use a short sale to help me stay longer, save money up, and then, maybe we'll sell the property, maybe we won't. This is what I would bring out. Like, this is, just to back up. I have all the stuff going up on UpsideDownRealEstate.com. But this is a tremendous form. So this explains what a short sale is. The point is at the very least, the lender has to release the lien. They don't have to release the loan. They might tell you they're releasing the lien, but you still want them to release the loan regardless of 580E. I've been saying that for years. I said it back then all the time. I'm sure I had it up in videos because we would get approvals. We would get approvals where they release the lien and not the loan. And they'd say, we're not under California law. We don't have to do it. If your client wants to do this, they have to sign this. And I was like, look, seller, whether California law is going to trump them over their federal theory claims, I'm not here to tell you yes or no. But I'm saying that if you sign this agreement, there's a risk that someday someone they sell these loans to is going to try to collect. And that's a hassle. So you want to get this removed. We want to get this removed, but it's up to you. Now, C.A.R is actually validating that advice. You just cannot work with a realtor alone. You need an attorney on your team to review, to leverage. We have a lot of laws right now. They may expire, and they even mentioned that they're temporary. But right now, tremendous laws to gain leverage over lenders in many different scenarios. So it's a major mistake to go right to a non-attorney realtor. And the language isn't always obvious about whether they're releasing the loan. Sometimes it's very vague. There are other times they're like, we're going to have you sign this agreement. You've got to contribute the money. You've got to bring in all your HOA fees back. You have to bring HOA back up to, a non-deficiency situation. Some are asking $8,000 or $10,000 supplement. They're like, well, I don't care where we get it. And sometimes they were asking more than the realtor fees were being. They're like, I don't care if we get it. We're not paying buyer agent fees or whatever they were doing. Like, there's no guarantee a short sale is going to be approved. So you have to have a backup plan. This form is telling us this. Alternatives to short sale, loan mod. Sometimes, most people didn't get good ones. A few people did. Many of them are coming due now. Foreclosure, absolutely an option for many people, for many reasons, especially if the lender's not releasing the lien or not doing the short sale in terms you like. You have to consider foreclosure as a backup. Deed in lieu of foreclosure, probably very rare now. They usually make you jump through the same hoops anyway. Maybe helps if you're working with an attorney who can also threaten bankruptcy, because then they're like, well, okay, if they're going to file, or maybe they just did. Sometimes people would file bankruptcy to stop a foreclosure, but they wouldn't go through with it. And that could be a time to get the deed in lieu without a lot of strings attached done. And then you don't have to do the bankruptcy. But, getting a deed in lieu and a deficiency release, you're going to want to talk to an attorney about that, because there's no point in being stuck, for me, because I care about my future. And I went in Florida where there were no deficiency laws back in the day. I went to the table with $70,000 just to get out of our final loan, because I didn't want the banks tracking me down for years and years. So if you can get out of a loan out here without a deficiency, you have to consider that as a better choice than some of the other options, in my opinion. But people are worried about their credit. By the way, there is an advantage to doing a short sale if you have a lawyer on your team who understands what the short sale law says and then tells the bank, you send your letters to the right people. You do it right after in the right time frames, and you threaten that if you do this to my client, we will act immediately. And your client has to be willing to probably back that up. But you could maybe get the type of mark on your credit that what a realtor is going to get on your credit is going to be, they're going to get a mark that signals for as long as different lenders want, that this person did a short sale. And so you could be looking at paying for 2 to 7 years, depending on their lending criteria, which we discuss later. Lender agreement to short sale. In order for a short sale to be completed, the lender at a minimum must agree to release the property from the lender's lien to allow the sale. The lender may or may not agree to reduce the amount owed to satisfy the debt. That's lien and loan. That was a major problem before the short sale law in, I think it was 2011. And that's going to be covered here. Prior to granting, if not, the lender may continue to pursue the borrower. The lender may or may not agree to reduce the amount owed to satisfy the debt. If not, the lenders may agree to pursue the borrower for payment of the balance of the debt. Prior to granting approval of the sale, the lender may require the borrower to disclose all of borrower's assets. That's a problem. If you don't get your... Oh, man, I remember this so well. You have assets, and the lender's playing games, and you don't make sure that you have a deficiency release in place, and it's a second loan, and the first is going to foreclose, and you got a sold out junior. That was a horrible situation some realtors put people in. You do not want to go 2 loans with a realtor. I can tell you right now, not unless you know your angle. If you have assets and you've disclosed them to get your short sale done, it's like, here's a roadmap to collecting from me when we're done. They may require the borrower to liquidate other assets. They may require the borrower to sign an agreement to repay some or all of the debt at some later time. They may require the borrower to secure the unpaid debt with other assets owned by the borrower. Additionally, they will require the transaction be arm's length, all except for the 10-year deal my friend was in. Finally, many first lien lenders will limit the amount they will allow to be paid to a second lien holder, further complicating negotiations for the short sale. The lender will usually submit a term sheet to the borrower indicating the terms to which the lender will agree. If the seller and the borrower do not modify their contract to comply with the lender's terms, the lender may not permit the short sale to proceed. Can you imagine doing that without an attorney? Sellers are strongly advised to seek legal and tax advice regarding review of the term sheet. Couldn't agree more. Thank you, C.A.R. Brokers cannot and will not give. Cannot and will not. That's the broker. You're dealing with probably someone working for the broker. Broker cannot and will not give legal or tax advice on the lender's term sheet or its effect on the buyer or seller agreement or the consequences to the seller or the buyer should they proceed to close. There is no assurance that once the lender have begun short sale negotiations, they will discontinue the foreclosure process. Well, that's why you have an attorney, because they can work on that for you. They have leverage over this circumstance. But your realtors cannot do this. This 3 is the great. Like, if you understand this and you go ahead and do this without an attorney on your team, well, no, let me put it another way. If your realtor does this without an attorney on their team, your realtor is not your friend. They're just seeing you as money. They're not helping you. They're not putting your best interests at heart. They're not helping you get a loan work out. They're not helping you know you've got a plan to recover your credit and your money when the short sale's over. They're just saying, I'm going to be super greedy and get paid for this short sale. I'm going to ram it through. I'll get paid. And boom, off you go without the very important legal and tax advice and credit posture that would be super important to you. Seller continuing liability on the debt. They keep explaining, though, this is so good. Many borrowers who attempt a short sale are concerned about whether the borrower was released from any further liability to the lenders, or whether the lender can pursue the borrower for any unpaid balance of the debt. Some refer to continuing liability as a deficiency judgment. Generally speaking, a deficiency judgment is the right of the lender to pursue the borrower for the difference between the amount the lender receives and the amount the borrower owes on the debt. Deficiency judgments in California are prohibited under certain circumstances. So that is pursue the deficiency. That is the language I used. And as a seller, you should be super concerned about that, because this can sometimes be big numbers and it can come to haunt you. And we're still seeing a haunting, even though they probably, zombie loans would have a very difficult time collecting their money if you have an attorney on your team right now. But if you try to do a short sale, they could get in your way. So you should gain leverage over your zombie before you even attempt to list your property for sale, because that might wake them up. And I don't know legally, I haven't even reviewed what that would mean when you contact them. Like, that's a very important thing to know before you talk to them. We're going to cover zombie loans in very soon in a video, because there's something very important about zombie loans right now. That the lenders, it's a very opportune, it might be an opportune time to perfect your rights with respect to zombie loans. And you might have a 3-week window. And this is now January 2026. Now, here's where we get into 580E. This is the thing that realtors who aren't lawyers tell people why they didn't need a lawyer if they're going to do a short sale. First of all, what if the short sale doesn't go through? It's the first question. Am I protected? How am I going to be protected? Can the banks pursue me? Can I protect my credit? Do I have tax consequences? If you're a realtor, tries to answer that, have them put it in writing and have their broker sign it. Especially when it just told you here. Well, you saw that, part 3. But 580 is very good. And if we get what we want, over time, more and more of our clients did short sales, because more and more, that's what the banks wanted, and more they were getting better deals, and the laws changed to help them. So 580 provides that a lender who approves a short sale in writing is not permitted to seek or collect a deficiency against the borrower if the loan is secured by a deed of trust on residential property containing 1 to 4 units. This law may not be waived by the seller, but they might ask. The July 15, 2011 law does not apply to lien holders on other types of companies. No, lien holders on other types of property. So this was for residential property, or borrowers of 1 to 4 units, or borrowers committed fraud or waste. I've been reading just today. I mean, because we had someone call about a short sale yesterday. I've been reading that this fraud or waste is being used by these collection companies. Borrowers, and remember, certainly a good example. I remember some people, buyers, coming in and saying the sellers had removed all the wires and the copper and and sometimes people destroyed the houses. So you would think that might be fraud or waste for sure, but this is an important thing. Fraud, another super important thing to watch out for. Even like if you're doing a short sale now, you better make sure, if you're answering the questions like they want you to reveal your assets, what if you don't reveal your assets? You better know from an attorney what your risks are if you're either going to hide it, because if they see that you hid it, it looks like they could seek a deficiency. This is what C.A.R is telling you. Borrowers who are corporations, limited liability companies, or partnerships do not get the benefit of 580E, according to this writing. Prior to this law coming into effect, on 2011, the restriction on lenders for seeking deficiencies for approved short sales only applied to lenders holding a first deed of trust on residential 1 to 4 units. I don't remember that. I'm gonna ask ChatGPT. No, I'll ask Google. Google's been very good lately. Gemini. I'm reading the California Association of Realtors short sale listing agreement, and they said prior to January 1st, 2011, which was 580E, restrictions on lenders seeking deficiencies for approved short sales only applied to lenders holding a first trust deed on residential 1 to 4 units. I don't recall a law. Like back then we were doing in purchase money, we were good, and we were always negotiating it, and lenders usually did on the first, but I don't remember the explicit law. But I do remember first were so much easier to get a release from the deficiency in writing than the seconds. But I'm trying to remember, can you remember what the law was? So they're saying before January 1st, there was no specific statute by 580E that explicitly governed. Here, I'll pull this over. Short sale. The C.A.R form is referring to SB 931, the first version of California Code of Civil Procedure 580E. Before it was only 580B and D. January 931, 580E. July 15th. So maybe their timing was off. Doesn't really matter. You want to work with a lawyer and get all this done, and then you want to know whether the lender is trying to make like I told my sellers then. You don't want to sign if you care. You don't want to sign one of those agreements that says you're still going to owe them money, or you're waiving you still accept the fact that they can come after you for the deficiency, because they'll sell off the loan, and someone who's not covered by California law and doesn't care might try to collect it, and then they'll continue to ring up your debt as a problem. So you want to make sure that the language is sufficient for you and negotiate for it. Even though 580E might prevent them from coming after you. Prior to this law coming into effect, restrictions on lenders for properties of borrowers to which 580 does not apply, some lenders in negotiating short sales will want the owner to sign a note for the balance of the unpaid principal. I mean, my experience was some still wanted people to do that. Some lenders in negotiating a short sale will want the owner to sign a note for the balance of the unpaid principal. Other will release the lien only, but not forgive the underlying debt. Some lenders will reserve their rights. Exactly. Thus, in these situations, whether or not the lender retains the right to pursue a deficiency following a short sale becomes a negotiable term for each sale. I can't believe how good they worded that. So they're saying it's negotiable term even though 580E applies, and that's just the truth. Your realtors who are telling you 580E protects you are lying. They don't know that. And we've seen it protect from what? What are they saying protected to? And are they going to put that in writing? Is their lender going to put that in writing? Don't be fooled. It's like I'm really offended by some of the websites I saw today about saying, don't be fooled by lawyers scamming you and scaring you. And I have a video on that from the old days. This is the C.A.R form that they have to have you sign. If you go sign a listing with an agreement, a realtor, and it's a short sale, you have to sign this. This is what they have to have you sign to list the property. For properties or borrowers to which CCP 5 does not apply, thus in situations where whether a lender retains the right to pursue deficiency, a short sale becomes a negotiable term for the sale. So that's for borrowers to which 580 does not apply. But it's still a negotiable term for when it does apply for some people. Like it, I think we just saw that they were telling us, generally speaking, there's still some lenders are still going to ask the lender. Okay, so the seller is encouraged to obtain written agreement from lenders or other applicable lien holders addressing whether and to what extent seller will be released from any monetary or other claim, obligation, or liability upon approval of the short sale, and have that written agreement reviewed by an attorney, CPA, or other appropriate professionals of seller's choosing. Okay, so this is the realtors telling you when you sign a listing agreement, you need to have an attorney on your team. That's it. Foreclosure, purchase money loans. This is, again, super good for people who might not even be doing a short sale. They're reviewing all the important law. Loans given by lenders to purchase 1 to 4 unit properties, one of which will be occupied by the borrower, and seller finance purchases are subject to purchase money anti-deficiency protection rules. Generally, this means the lender cannot pursue the borrower for any deficiency after the property is foreclosed. Like, this is the law I can coach people on. Right? This, I believe, it's worked over and over upon the seller or lender, whether the seller or lender uses a non-judicial trustee sale or judicial foreclosure. It doesn't matter if they go to court or they go to a trustee sale. And they almost always go to trustee sales unless there's fraud and some other problem. Like, there's problems with title, in my experience. I only saw 2 judicial foreclosures that whole past round. Maybe it was 3. It was under 5. Refinancing a purchase money loan causes it to lose any purchase money protection it might have. Now, I trust the C.A.R lawyers on this, but we want to come up to speed on what happens if you refinance a purchase money loan and the amounts don't change? Or what if it only goes up $20,000? At one point in time, that was the rule. I'm going to ask Gemini again. If a owner refinances a purchase money loan in California, does the loan automatically lose its non-recourse nature? Not anymore, but it does depend on when the refinance happened and what the money was used for. For a long time, you were right. Refinancing was a trap. However, the law changed to specifically protect debt-trapped people. Well, I'm not going to put. I got to go back and check my brain against the statutes and read it, or I will post it eventually. I mean, I already have it, but my brain was saying I thought that changed. Google agrees with me, but I'm not comfortable giving advice on that. So let me say, don't give up necessarily just because you refinanced your loan, especially if you didn't take any cash out. It'd be a two-step analysis, but what if you took cash out? The cash out part probably wouldn't. This is now 10 years old. I'd say the cash out part probably does not retain its purchase money. But I promise you, I wouldn't rely on what I just said. I will tell you when you can rely on what I'm saying. It's because I'm reading the statute to you. And I'm going to say, this is what the statute says. I'm not giving you legal advice on this. If a lender forecloses by non-judicial trustee sale instead of a judicial foreclosure, that lender is barred from seeking any deficiency. I feel very comfortable with that. Very well tested. So a non-judicial foreclosure, and like the first forecloses, they're not going to be able to come after you. The second forecloses, they're not going to be able to come after you, but then the first would have to foreclose. But if you let the first foreclose first, and then you still have a second, then you got a problem unless it's a purchase money loan. Well, I'm not going to even say that. Then you might have a problem. Let's put it that way. Anti-deficiency protections become much less clear for loans that are refinanced. Generally, loans that are refinanced lose their purchase money protection. Lenders extending refinances may be able to pursue a deficiency judgment against borrower directly following a judicial foreclosure. However, beginning January 1st, 2013, borrowers who refinance a purchase money loan on owner-occupied residence with 1 to 4 units and do not take any cash out from the refinance will receive. So there was a change there. I think C.A.R's point is a good one. They're saying, what if you refinance much earlier than that? So if I did that refinance before 2013, I would definitely talk with a lawyer. I would have to look that up for you. I have to see the cases. Junior liens. This is probably where they're going to say sold out juniors. The anti-deficiency protection for junior lien holders are also somewhat unclear. Junior debt to junior liens that are refinanced or junior liens that are used to take out equity do not have purchase money protection. Such non-purchase junior lien holders may be able to pursue a deficiency against the borrower directly after a trustee sale by a senior lien holder. Although the law is not entirely clear, home equity loans may fall into this category. Yes, I remember those arguments. Sold out juniors, you have to watch out. That was one of the first things I learned when I got out of law school, when I went to work at the firm, and I was talking to the bankruptcy lawyer at the firm. And we were talking about loan workouts and when they were important. And he said it was always, if there's 2 liens, it's important because you got to watch out for sold out juniors. Other liens. Many other types of liens may be recorded on title, including without limitation HOAs, judgment liens, tax liens. Generally, foreclosures by any lien holder senior to such liens do not protect the owner of the property from later legal action by lien holder to collect an obligation. Again, watch out for sold out juniors. Credit and tax consequences. This is a really good. All of the owner's options discussed above will most likely have a negative impact on the owner's credit, true, and the owner's ability to finance or purchase properties for some time. And I did cover the credit impact and length of time the owner would have difficulty in obtaining a loan to purchase property again, or to be approved for any other credit transactions such as obtaining a credit card, leasing an apartment, or even gain employment varies. Lenders may view short sales and alternatives differently depending on their own underwriting guidelines and those established by governmental and quasi-governmental bodies. To find out more information about the impact of your credit score, go to FICO. I really like the fact they use quasi-governmental bodies. You know, after all, what is the Federal Reserve? You know, and what are banks and the institutions that govern them? I mean, we know the Federal Reserve's regional reserve banks are owned by shareholders, and while they're not like a publicly traded corporation, they are like a private corporation. So what are they? I'm so glad they said quasi-governmental. Now, this point is that anyone who's advising you on the effects of a short sale, like lots of people used to say, short sales are better for you in the eyes of the lender than a foreclosure. And some lenders would argue wrong. They're like, we don't care. Other lenders are like, oh, we just want the property back. If you talk to us and you give us the property back, we might like you more with taking the quick foreclosure than doing the short sale. So I think it all depends on what the banks are in the mood for. Because some of our original people and some of the other original people were getting to buy properties 2 years after their short sales when the market was still in flux, and then later people will have to wait their full 5 or 7 years. But let me just remind everyone, if you do a short sale and you talk to a lawyer, there are arguments to stop the lenders from reporting your loan as settled for less than the full amount, or however they want to word it in their nomenclature, which is a very detrimental mark. And a lawyer can help you to prevent that mark from recording or force it to be fixed. But I'd start early. Don't let it get recorded. Start the second your short sale gets approved, get to work. I think it'd be very important. I can't wait till it gets litigated. And I can't tell you exactly that it works because it hasn't been litigated. But I've done the research, and and I believe it to be a strong argument. And you really do want to get to work on it before they get to report it to the credit agencies. You could stop it in its tracks. You might be able to stop it in its tracks. With some exceptions, a reduction or discharge of debt obligation by a lender results in income to the borrower. So, like, you get a $200,000, and this is another thing with the zombie liens and what's going on. There's new laws that are stopping these large deficiencies from happening in the reports, and you need to be on top of it. You don't want to see income of $200,000 because that's what the deficiency was. You don't want to have to pay that on your income. And the laws have changed. One of the great ones, the Mortgage Debt Relief Act or Forgiveness Act, expired just last year. So you want to make sure that you can handle the risk of tax based on your loan workout, and can be based on whether you have a recourse or non-recourse loan. With some exceptions, a reduction of discharge of debt obligation by the lender results in income to the borrower. The income might not be taxable if the debt was being used to acquire, construct, or substantially improve a borrower's principal residence. Another exception, and I was checking this out yesterday, independent of this, about loans, if you took them out and you used it to improve the property. And an AI told me no, because it was saying the difference between how the IRS, I can't really rephrase the argument, but if this is going to impact you, I will do the research in the case law if you're working with me. Another construct or substantially improve a borrower's principal residence. Another exception exists if the forgiveness of debt results from a situation where the lender is barred by law from forgiveness of debt income. is barred by law from collecting the debt. Another exception exists if the forgiveness of debt results from a situation where the lender is barred by law from collecting the debt, as in a foreclosure of a purchase money debt. Insolvency and bankruptcy rules can also shield a borrower from forgiveness and debt income. Generally, when any debt is forgiven by a lender, they are required to provide the borrower a 1099, and it will be up to the borrower to make the proper claim on their tax return to avoid debt forgiveness income. Now, there's also an argument. Well, I'm not going to get into that. If you have to worry about debt forgiveness argument, let me give you talk to me and I'll tell you what I would do. I'm not going to guarantee it works, but I'm a lawyer and I see how these statutes are written and I see analogies and I'm saying, why would this be different than a purchase money situation? And I discussed this and I was like saying, but, and I was like, but. And there's arguments on both sides. It's not clear. So you could see a substantial improvement in your situation with good arguments that a lawyer can help you with respect to income. Who wants a $200,000 income to have to pay taxes on? Right? Barred by collecting the debt as in a foreclosure or purchase money debt. Insolvency and bankruptcy rules can also shield a borrower from forgiveness of debt income. Generally, when any debt is forgiven by a lender, they are required to provide a borrower with 1099 and it will be up to the borrower. In other words, you can recharacterize their 1099 with a note to the IRS. And it's up to you to make the proper claim on your tax return to avoid debt forgiveness. So I'm telling you, you want a letter from a lawyer if if the lawyer agrees, telling the bank to recharacterize that 1099 because those 1099s come out and they're frequently wrong. Some of these rules are temporary and state laws and federal laws differ. Also very important to note. Broker has advised seller that if a lender agrees to accept less than full payment, the difference may result in taxable income to seller even though seller does not receive any cash proceeds from the sale. Seller may also be taxed on the gain in the value of the property from the date of the seller's purchase to the date of the sale, regardless of the amount of any existing loan. So they're still saying you might have capital gains regardless. And I mean, you really need to talk to an attorney about the tax implications of what you're doing. Seller is advised to discuss with a qualified California real estate attorney, C.A.R. or other professional of sellers choosing before accepting any offer to present to lender or agreeing to any charges requested by lender to an already accepted contract. Potential improprieties. It is an unfortunate reality that many persons, including real estate licensees, mortgage lenders, and attorneys, among others, have taken advantage of owners of underwater or distressed properties. Luckily, they didn't write upsidedownrealestate.com. No, I'm kidding. We didn't take it. We would never. We didn't and we don't take advantage of people. We give them advice and we help them. Some of the schemes present themselves as rescues of the homeowner, promising to let them stay in the property, protect their creditor, provide payments to them after closing, and usually outside of escrow. Yeah, this is where people were trying to get really cheap short sale deals done. They said they'd split the money with their profits or whatever with people later. Both the California Department of Real Estate and the California Attorney General have issued written warnings of potential red flags in short sales and other rescue schemes. Some of these red flags are no license. The DRE believes that a real estate license is generally required to negotiate any short sale. I believe a law license is generally required to negotiate a short sale with the bank. You can negotiate the short sale with the buyer and the seller, but that was a very tricky word. I think you should be a lawyer to negotiate, or working under a lawyer to negotiate with the bank, but I'm not going to push that. MARS, short sale negotiators who do not represent a seller or buyer in a short sale are generally required to comply with the Mortgage Assistant Relief Services rules and provide required disclosures and notices to sellers. I don't see how a realtor, well, it doesn't matter. I don't need to make that argument now. Upfront fees. No real estate licensee can collect any upfront or advance fee without having first obtained a no objection letter from the DRE. And no upfront fees may be taken for arranging loan modification. I'd have to remember, I think lawyers frequently argued that were covered under that, but there were exceptions for lawyers. Realtors can't take up upfront fees. I wouldn't take an upfront fee to negotiate a short sale in any circumstances I could think of, but I'm not gonna say always. But there, for the loan workouts, for the short sales, for the walkaway plans, for understanding your timeline, for stopping foreclosures, attorneys are super helpful. Charges by third parties that are not disclosed to the short sale lender and usually paid outside of, those are surcharges outside of escrow. So that is a potential impropriety. Third party negotiations, the licensing and fee requirements. Oh my goodness. Let me pause and bring that back up. I guess I timed out. So hopefully that was pretty seamless. My form's timed out. We were talking for too long. The licensing and fee requirements above apply whether the negotiator occupies through a broker representing a seller or a buyer in the transaction, a third-party short sale negotiator. As with other real estate activities, short sale negotiator fees are negotiable and not set by law. The existence, fee, and license status of a third-party short sale negotiator shall be disclosed to the lender and must be approved by the lender as part of the overall compensation to be paid in short sale transactions. That's interesting because realtors were just paying the short sale negotiator out of their own fees. Here, C.A.R saying the negotiator is, their fee is going to have to be approved. The existence, fee, and license status of third-party short sale negotiator shall be disclosed by the lender and must be approved by the lender. Disclosed to the lender. Interesting. I don't know if the rule or the laws changed. What if the realtor is just someone in their office is helping them out? Straw buyers and house flipping. Buyers represent the value of the property to the short sale lender and flip the property to another buyer already in place. That's a potential impropriety. Other potential red flags. Guarantees to stop the foreclosure. No one should guarantee it, but they can show you the law and how to leverage it. Instruction not to contact the lender. Yeah, that's interesting. That you could get hammered. Transfer of title prior to close, often to a trust. Yeah, that people thought that was great stuff. It caused problems. I'd have to remember those schemes. A condition of negotiating with the lender, as a condition of the buyer is an LLC, the buyer wants the power of attorney from the seller, and the buyer hires a third-party negotiator and wants to negotiate directly with the lender. Those can be problems, yes. While most of the activities on the above list, on their face value, are not fraudulent, they serve as warnings. Yeah, real estate licensees must exercise care to ensure they're not acting as foreclosure consultants or offering mortgage assistance relief without providing notices and disclosures to short sale owners. So, we're going to cover this more. Let's just finish. We've come this far. In early 2012, California joined a national settlement agreement between 5 of the nation's largest lenders. In most states, the settlement obligates lenders to, among other things, write down or refinance some loans. That means take a loss on them, write them down, let people maybe negotiate them for less, extinguish certain unpaid balances, and provide transition assistance to some homeowners. Loans owned by Fannie and Freddie are not covered by the settlement. In the fall of 2012, California enacted a series of laws effective January 13th, commonly and collectively referred to as California Homeowners Bill of Rights. These laws prohibit foreclosures while an approved short sale is pending or while a loan modification is in the process or an appeal, as well as other requirements. Whether a borrower qualifies for any of the advantages of the settlement or homeowner BOR requires an analysis of the borrower's loan and the applicability to either of these items. Such an analysis is beyond the scope of a broker's expertise. Right. And how could you want the foreclosure to continue while you're working things out if you do not have a lawyer on your team to help you and prevent it and stop it? Or how either of these items can affect a short sale transaction. That party should discuss the matter with a lawyer or an accountant of their own choosing. A real estate broker cannot give legal or tax advice in connection with any of the options available to the borrower, nor can a broker suggest what is the best course of action for the owner. In other words, the sequencing of your workout and your strategy and your leverage, they cannot open. I know they do, but they can't do it. And when they make mistakes, you should sue them. Unfortunately, the owner is faced with extremely difficult choices, having a lasting impact on the owner. Owners are strongly cautioned that they must seek legal and tax advice in what is not only a choice impacting taxes and credit, but also personal issues affecting the owner and often the owner's family. Yes. This form is outstanding. It causes marital problems like you would not believe. The broker's role is to assist, and it is important. If you have a lawyer in there, many people sought my advice or came in and sat down with their family because one person, and believe me, I'm not saying it definitely was not always the woman. Sometimes a woman brought the husband in because the husband was being irrational. Someone's being irrational and they don't believe anybody and they want to talk to a lawyer who understands the roles and can give them a workout and calm people down and get things done. Other times, it's just some of the nastiest stuff. Just sad. Other times, people crying and saying they lost their inheritance and everything. They followed, I'm going to say it, that rich dad, poor dad guy's advice and bought a lot of real estate and got smoked and even used their wife's inheritance to do things. I mean, it was really sad stuff. Be proactive. Don't let you, so sad. Some people, really good people who wanted to honor their word, drained everything before they sought help. I'd say don't be that person. Or if, I'm not, this is tough. Talk to me on the phone. Brokers do not and cannot assure either the seller or buyer will perform on their agreement or that lenders will agree to any of the terms presented. Brokers are not party to a contract between buyer and seller. Let me just review this. Owners are strongly cautioned that they must seek legal and tax advice in what is not only a choice impacting tax and credit, but it's personal to the family. The broker's role is to assist the owner with the actual sale of the property in a short sales transaction, not to provide legal or tax advice or to guarantee the best possible outcome for the parties, or to assure a buyer that any particular transaction will be completed. Broker authority. Seller authorizes broker to market the property for sale, contact lenders regarding lender's approval for short sale, C.A.R. form ARC. Seller agrees to give broker any necessary information, negotiate with lenders, and advertise in the MLS and other advertising media the property transfer, sale price, and payment of commissions are subject to lender's approval. If the lenders will not cooperate, broker may cancel the listing agreement. All right, my name is John McConnin. This is the first in a new series for UpsideDownRealEstate.com. You'll see lots and lots of posts. I'm going to try to get them into more of a format. I've had videos from over 10 years ago on the internet. UpsideDownRealEstate.com even has its own channel, but only 5 or 6 videos in there. Thanks. If you have any questions, contact me. We have free consults, and we'll ask you what you want to achieve, and we'll see if we can help you achieve your goals, and then we'll explain how it will work, what it would look like if you're working with us. Thanks. Talk to you later. Bye.